Hello, this is Scott Horton. We've just opened the webinar live to attendees, so we will be getting started in just a few minutes. In the meantime, people will start joining, and you should see the cover slide of the presentation on your screen. Welcome again to those that are joining the live webinar now at this time. You should have access to a chat window, and you should see the cover slide for today's presentation, New York Sexual Harassment Training Update, on your screen. We will get started as scheduled in just a few minutes as everyone has a chance to enter the webinar. Thanks again for joining. If you have the cover slide of the presentation on the screen, then you should be good to go, assuming you can also hear my voice. We will get started in just a few minutes. Make sure you know where the chat feature is located so that you can enter questions if you have them during the presentation. I'll go over everything again when we get started in just a couple of minutes. Thanks for joining. Once everyone has a chance to access the webinar, we will get started. If you can hear my voice and you have the cover slide for today's presentation on the screen, New York Sexual Harassment Training Update, then you should be all set, but you can also check to make sure you know where the chat function is located if you need to ask questions or have other comments during or after the presentation. Again, just another minute or two, we will let everyone have time to join, and then we will get started. For those who are just joining, we are about to get started with the presentation. We just want to make sure everyone has had a chance to log in, who's able to. We'll go over some of the logistics again when I get started, but you should be able to hear my voice and see the cover slide of today's presentation on the screen, and you should also have a chat window or box on the screen that you can enter questions into. Just going to wait about 1, maybe 2 more minutes and then get started with the presentation. So again, thanks for joining us for today's webinar. I will just get started with a couple preliminaries as people probably are still in the process of logging in. Again, my name is Scott Horton. I am founder and attorney with Horton Law PLLC. My office is located in Orchard Park, New York. Today's presentation will be on the New York Sexual Harassment Training Requirements. This is an update. These requirements started to go into effect last year, and I gave presentations at that time. But with the first annual training deadline coming up, in October. I wanted to throw some reminders out there for everyone, as well as let you know about some changes to the requirements that actually took effect last week. Were signed into law last week and took effect immediately. There are some other changes to New York's law related to sexual harassment in the workplace that we will also touch on. I've done another webinar recently on that if you need more information on it, but to the extent it touches on issues that affect how you might conduct your training, I wanted to provide that information as well. Just by way of background, I want to point out the two sources of workplace sexual harassment laws that affect employers throughout New York State. Title VII of the Civil Rights Act of 1964, to be specific, is a federal law that covers employers with 15 or more employees and allows employees to file claims of employment discrimination, including harassment, with the U.S. Equal Employment Opportunity Commission. The EEOC has recently demonstrated a lot of focus on the issue of sexual harassment, and that is something that would apply to any New York employers with 15 or more employees. The New York State human rights law prohibits sexual harassment by all employers in New York State. Even if you only have one employee, employees can file claims with the New York State Division of Human Rights, or in fact, they can file lawsuits directly into court without going to either the EEOC or the New York State Division of Human Rights. And while for many, many years, decades, the New York State human rights law, with respect to the workplace anyway, has protected employees and not non-employees, amendments in the last couple of years have expanded that so that now sexual harassment claims can be filed by non-employees such as consultants, vendors, independent contracts, interns, etc., in New York State against their employers. Against employers in whose workplace they are working. So if you are an employer or you work for a company that has employees and an independent contractor comes in, though they're not your employee, they could still file sexual harassment claims against your organization. In the not too distant future, the New York human rights law will cover harassment claims by consultants, vendors, independent contractors for harassment other than sexual harassment in some amendments that have been signed into law but have not taken effect. But today we're only talking specifically about sexual harassment, and that is already in place. Okay, so when I did this presentation last year, this slide said new requirements for all New York employers. And it was an aspect of the 2018 New York State budget legislation, and it required that all employers have a written policy in place by October 9th of 2018, which hopefully all of you and your companies and organizations have complied with. And then eventually there was clarification that the annual training deadline would take effect beginning October 9th, 2019. So a month and a half from now is the first deadline for all New York State employers to provide sexual harassment training to their employees, and then they would have to do so annually thereafter. Before I go any further, two more logistical things I wanted to point out. One, again, you should have a chat window available to you, or chat box. You can type questions in there. I will allow time at the end. I don't expect to go past an hour for the presentation. If questions push us beyond that point, I will stay on to answer the questions as long as it takes. If you're not able to stay on to the end and have questions, you can contact me separately. The other point I want to mention is that all of these slides will be made available to you. I will have a link at the end of the presentation where you can click over and download those for your reference. If you do have questions as you go, please type them in so you don't forget them. But for the most part, I will wait until the end to answer the questions. So as I say, these requirements have been in effect since 2018, but not everyone has completed their annual training requirement. So many of you may be familiar with New York State's website by this point on combating sexual harassment in the workplace. There are a lot of materials available at this website, including model policies and sample model training materials. Just briefly, also want to mention this is all the New York State's information and requirements. Employers in New York City are also subject to the New York City human rights law, and they have separate sexual harassment training requirements that went into effect earlier this year. Even employers in New York City are subject to the New York State requirements, but some of them would also be subject to the New York City requirements. There is, I believe, a 15 employee threshold for coverage under the New York City human rights laws requirements, and that includes not only employees but also independent contractors, for example. Both the state and the city have prepared their model policies so that they are intended to satisfy both state and New York City requirements where applicable. But again, just to note that there are additional requirements, but in this webinar, we're talking about the New York State requirements specifically. Because again, even if you are in New York City, you have to satisfy the state's requirements. Okay, so the sexual harassment training requirement that went into effect beginning last year was a little bit open-ended by law and required the Department of Labor to set some more parameters. The state's original deadline for training all current employees was January 1st, 2019. That was later revised to October 9th, 2019, which is still the applicable deadline. So I guess the state figured January 1st was too quick to require everyone to come up to speed, and they gave everyone more time, but that more time is now coming to an end. Once you have satisfied the initial training requirement, you will have to train all employees annually after 2019. You can set your training year based on various factors, the calendar year, an employee's anniversary date, or some other date. For example, you could use October 9th every year. I think my general recommendation, based on the factors I've considered, would be to plan to use a calendar year. So if you have provided your training earlier in 2019, you should be fine to provide that training again in 2020. Even I think if it's more than 1 year after your original training. For example, if you provided training back in March and then next year decide to provide training in June, I think you're going to be okay in satisfying the requirement. But for other reasons I'll mention in more detail later, I do think you should try to provide the training on a close to annual basis, in the sense that it wouldn't be ideal to do it in January of 2019, for example, and then wait until December of 2020 to provide it again. So try to keep it roughly a year apart. The employee anniversary date would really only make sense if you were providing the training at the time of hire and then making sure you provide it for each person individually again by their anniversary date. but most employers are not going to be providing individualized training. If you have, a reasonable size group of employees, you're going to want to do a group session. So having a uniform year for training purposes probably is going to make the most sense. Again, there could be specific reasons why your organization should do something different, but that's just sort of my general thoughts on that. At one point, New York State suggested that there was a short time period for training all new employees. They've backed off of that in the now applicable guidance. There's no specific time period, but they encourage training new employees as soon as possible. I think if you had a new employee come on and you had a group training session planned for all employees in the next month or so, you probably would be fine waiting until that training session to train your new employee. But on the other hand, if you had just provided your annual training to all existing employees and then a month or two later hire a new employee, then it would make sense to hire or to train the new hire in the orientation process or as soon as possible thereafter. I think most employers, or at least of relatively substantial size workforces, will want to do some training on sexual harassment as part of their new hire orientation process, if nothing else, just to make sure you satisfy the annual training requirement, because it is an annual training requirement for all employees. And it doesn't matter if you've already provided your annual training to other employees, you still have to train that new employee annually, including in that first year, presumably. Now, I just wanted to make this a little bit interactive here and throw up a quick question that you can all click to answer. And that is really asking whether your company or organization has completed the initial annual training requirement. So if you can click the choice that applies. Oh, I'm sorry. I think the sound went out for a few minutes. I just want to pick back up. I'll start back on this slide. I apologize, we have fixed the sound issue. Can somebody remind me the last thing that you did here? Okay, so we voted. Most people had completed the training, some had not. I'm sorry. So now starting back on this slide, this is what is required for the sexual harassment training to meet the state's requirements. Under New York state law, there must be annual training, it must be interactive, and it must include these components. The first is the explanation of sexual harassment consistent with guidance issued by the Department of Labor in consultation with the New York State Division of Human Rights. Because the law on sexual harassment is changing, primarily to lower the threshold for what qualifies as unlawful sexual harassment, it is probably likely that this guidance will change, and that may change what has to go in the training. For now, we don't have more information specifically on that. You also have to include examples of conduct that would constitute unlawful sexual harassment. This generally isn't complicated. There's a lot of types of conduct, behavior, etc., that would qualify potentially as sexual harassment and even possibly unlawful sexual harassment, again, because the law is changing to lower the threshold between what is or isn't unlawful. That could change the guidance in that somewhat. Information about the federal and state statutory provisions concerning sexual harassment and remedies available to victims of sexual harassment. The federal Title VII and state New York State human rights law provisions themselves have been in place for a long time, except the state provisions are being amended, as are the remedies available, which I will discuss later. So again, that could change what has to be in the training. That will not take effect before October 9th. So I don't think you have to try to include anything new before October 9th to meet the state's training requirements. However, as you will see, those changes start to take effect very soon after October 9th. So you may want to consider addressing that if you're still planning to have training between now and then. But it, again, is something that might have to change, not only actually in your training, but also in your sexual harassment policy in the relatively near future. Information concerning employees' rights of redress and available forums for adjudicating complaints. For the most part, that's not changing. So that's to say you can go to the EEOC, you can go to the New York State Division of Human Rights. In New York City, you can go to the New York City Commission on Human Rights. The state guidance also mentions that you can go to the police if it rises to that level. And for the most part, again, those forums are not changing. However, employees will have more time to file a sexual harassment case in court beginning later in 2020. So that is something that will probably have to be changed in your policies at that point in time, but it would be difficult to change it now, because if you change it now, it wouldn't be accurate. So unless you're going to spell out the date when the change takes effect, that is not something that necessarily has to be addressed immediately. Finally, the training must include information addressing conduct by supervisors and any additional responsibilities for such supervisors. This includes, for example, instruction that supervisors must report all information related to sexual harassment to the appropriate people within the organization so that it can be investigated and dealt with. They can't honor request by employees to keep something confidential or not go any further with it, and that supervisors, of course, can't themselves engage in sexual harassment or otherwise condone or allow it to occur. So all of this has to be addressed in your training. There is no specific time requirement for this training. If you really just wanted to be able to say that you met the state training requirement on an annual basis, you could probably cover all of the material necessary in a relatively short period of time. I have not tried to time how quickly I could go through everything I think would have to be included, but I suppose you could probably do it in 15 or 20 minutes. I think the longer the training, the better. Again, we'll get into it in more detail, but beyond trying to satisfy the state requirement, I think the real value in the training, which you now have to do, and even before that probably should have done on a periodic basis, is to try to actually prevent sexual harassment. And therefore, a more involved training is probably going to be more effective than the minimally sufficient one. So the training does have to be interactive. These are New York State provided examples, so they don't really give us a bright line as to what qualifies and doesn't qualify. They just say things like this would or wouldn't be okay. These things would be okay if the training is web-based, has questions at the end of a section, and the employee must select the right answer. If it's web-based and the employee has an option to submit a question online and receive an answer immediately or in a timely manner. So, it doesn't have to be a person that's able to interact with them instantly, but if they can submit a question and then get an answer at some reasonable point in time. And in-person or live training where the presenter asks the employees questions or gives them time throughout the presentation to ask questions. So that's probably what most in-person or live trainings would look like. But hypothetically, if you had somebody stand up in front of the room, read out a bunch of information, and then walk out with no opportunity for people to ask questions, that would not qualify as interactive training. And web-based or in-person trainings that provide a feedback survey for employees to turn in after they have completed the training. Now this, I think I would consider to be on the very low end of interactivity, if you will. A feedback survey isn't the same as actually asking a question and getting an answer, but the state has suggested that that would be sufficiently interactive. Again, not what I would recommend for the highest quality training experience and the most effective results. A couple more comments from the state. An individual watching a training video or reading a document only with no feedback mechanism or interaction would not be considered interactive. So if you just set somebody down and say, here, watch this video, and that's the extent of it, that would not meet the state's requirements. Again, it would be better to have someone there with them, or at least at the end of the video, where they could then ask that person questions, and the person could either give answers or take notes and get back to them with answers once they've had a chance to look into it. States also indicated that while a best practice for effective engaging trainings, a live trainer is not specifically required. Live trainers could appear by phone or in person, video conference, however. But they also note that there is no certification required and the state does not currently certify or license training providers. So like many other things, there's probably a wide variety of quality in the live training that you could outsource at this point. I know I was immediately inundated as a business owner myself with various solicitations from insurance companies and payroll companies and consultants, and I don't know that any lawyers contacted me, but certainly lawyers were doing this as well. So everybody was trying to provide this training, and you just have to find training that makes sense for your organization. That is a question I also was going to put out for poll for curiosity. And that is, what type of training is your organization using? So the choices I have are live outside trainer, meaning someone you bring in from the outside, a live inside trainer, you're using your own staff, video or web-based, or finally undecided or I don't know. I suppose some of the people who don't yet have a plan for the training might still be in that last category, and otherwise there could be some that have used a combination of approaches, and I didn't provide for all of that. Looks like about half are using live trainers, most of those doing that in-house. And then the other half are either undecided, don't know, or using some sort of video or web-based approach. Okay, so the state last year put out their model training programs. The model training package, I suppose, included when they put it out, and they haven't updated it since last October, a 32-slide PowerPoint presentation, a training script, and a separate PowerPoint with an additional 66 slides of sexual harassment case studies. So again, this is not necessarily intended to be what you have to use or even what you're encouraged to use. It's just something the state had to provide, at least for employers that weren't going to go beyond what the state told them they had to do. So you could load this PowerPoint presentation with the 32 slides, have somebody read off the slides, and have people answer questions if anyone in the audience asks questions, and probably satisfy the state requirement. The sexual harassment case studies, I don't think in any reasonable training session could anyone actually get through all 66 slides. I think it's more intended that you could pick and choose among them for what makes the most sense for your workplace. But again, certainly you could come up with your own examples or hypothetical situations as well, though that is not a specifically required aspect of the state training program. So since you're doing so well at answering questions, I want to just ask one or two more before we're done. And this one is whether your organization either has used or will be using the New York State model training materials. So the top answer, yes, is the primary material stormed out to an early lead and is still holding strong. But we have had some add that they're only using them for reference or they're not using them. And I suppose it is possible that some people who have brought in an outside trainer, their trainer has used them and they may or may not know that as well. But regardless, it looks like the overwhelming majority of you have used them as their primary materials. Probably those of you who are using in-house staff to present the training have adopted the model training. And again, that is what the state expects you to do at a minimum to meet the requirement. Whether that is ultimately the most effective training possible, of course, goes into a cost benefit analysis for you. I didn't ask the question, but something else to consider is what the average time of this training is taking. I think if you're not spending an hour on this training, then you're probably doing it too quickly. But that's not to say that the law requires you to spend that long. And I have certainly provided harassment training and been in an organization, a law firm, where our training was longer than an hour and sometimes much longer, more like 2 or 3 hours. So there's a big range there. But again, the state requirement can be met relatively easily. So that raises the question then, should we use the model training? Here's just some pros and cons to think about. Pros, well, it should satisfy the requirement. It's relatively quick and cheap. And there is training available in other languages. So some of the negatives to using it, perhaps, depending on your situation, is that someone still has to present it. Not every business has someone who could present it effectively or as effectively as they would like, or for other reasons you might prefer to have someone from outside the organization come in to present it. Perhaps that would give it heightened importance or cause people to listen more seriously, or maybe not, but that is a consideration. You are relying on New York State to update the content. As I noted, they haven't done so since October, even though laws are starting to change that might be relevant to the content. The state is now required to reevaluate and update the model policies and training programs every 4 years, beginning in 2022. So that is a new law that was just passed this summer. I think at this point, if the state waits until 2022, then you are not going to want to continue to rely entirely on the model policies and training, because laws are changing between now and next year that should be addressed in both the policy and training. Most likely, the Department of Labor will update its model policies in response to those significant legal changes, but they're not specifically required to do so until 2022. Okay, so now what I want to do is move on. So that all of that is really the same stuff for the most part I could have told you this time last year, but there are a couple of new requirements that are in effect now. So in July, there was a large package of employment discrimination, harassment, and in some cases sexual harassment specific legislation that was passed by the legislature. It then couldn't become law until the governor signed it, of course, which for the most part he didn't do until last Monday. On August 12th, he did sign, making a lot of these amendments effective at various dates over the next year. Among the couple that took effect immediately were changes to the sexual harassment training requirements. These related to distribution of the policy itself and written materials for your training sessions, and language requirements regarding both of those things. So again, this is in effect now. If you have not done the training for your first year before today or before August 12th, then these obligations apply to this training that you still have to do before October 9th. And for everyone, whether you've done training yet or not, they will apply the next time you do the training. So all employers must now give each employee a copy of their sexual harassment prevention policy at each training session. Honestly, I think this would have been the best practice even before, but it wasn't specifically required. So now it's required at the training session. Suppose you bring in all 50 of your employees for a big training. You have to give each of them a copy of the sexual harassment prevention policy at that time. The state does not require you to get assigned acknowledgement, but I would recommend that you get at that time both their signature that they attended and that they received a copy of the policy. The more complicated requirement is that the law now requires all employers at each of these sexual harassment training sessions to provide a written copy of information presented at the training. It's not completely clear what that means. You most likely don't have to give them a script of the written or of the verbal material presented, whether by a live presenter or by a video or recording, for example. But you have to provide them some written information, and I would think that means something along the lines of a copy of the PowerPoint slides, if the presentation includes that, or an outline of the information that is presented. Again, we may get further clarification on this from the Department of Labor, but as far as I know, we don't have that yet. And as I said, this requirement is in effect now. A couple more comments on that, but before I get there, I want to put in the other piece of this. You also have to provide the policy and the written copy of information presented in the employee's primary language if the state has model forms in the language. The current languages available through that New York State website on combating sexual harassment are Bengali, Chinese, Haitian Creole, Italian, Korean, Polish, Russian, and Spanish. As far as I can tell, all of the materials that are available in English are available in these languages. I'm not fluent in any of these languages, and some of these languages, when I open the documents, I can't even begin to orient myself as to what they contain because they use characters that don't even resemble English letters. But as far as I know, they are complete and consistent with the New York State model forms. Here's where the complication comes in. You have to provide your policy and the written copy of information presented in the employee's primary language if New York State has model forms in the language. If you have not used the state's model forms, but you have an employee whose primary language is one of these 8, you are still obligated then to translate your policy and the written notice of information presented into that language. All of this, by the way, doesn't depend on whether the person is fluent in English or the extent of their ability to communicate in that language. So if you have someone, whether they're fluent in English or not, but their primary language is Korean, and you use your own sexual harassment policy, and you have training tomorrow, then as I stand here right now, I would have to say that your obligation is to get that policy translated and give them a copy of it in Korean tomorrow during your training, for example. There is a question that just came in. I can answer it easily. Must it be a hard copy, or can the materials be emailed to the employees? Yeah, you can provide it either way, technically, but it does say that you have to provide it at the training. I suppose then you could email it to them if they had a device in front of them where they could see it at the training. I think you could probably email it to them right before the training. But I probably wouldn't risk it too much if there's any ambiguity as to whether the person will have a copy of it available to them at, whether it be the beginning or end of the training session. So here's the big loophole in all of these requirements and the new amendments, and that is, does the training have to be presented in the employee's primary language? So looking at the new statutory requirements, the law specifically says you have to provide a copy of the policy and the written notice of the information presented in the training in the employee's primary language if it's one of those that the state has model forms for. The state website right now has this answer to the question. First, it says yes, but that's probably misleading. It then goes on to say employers should provide employees with training in the language spoken by their employees. When a template training is not available from the state in employee's primary language, the employer may provide that employee an English language version. However, as employers may be held liable for the conduct of all their employees, employers are strongly encouraged to provide a policy and training in the language spoken by the employee. So the yes answer at the beginning of this is probably not consistent with what the law actually says. And the fact that they then go on to say should instead of must seems to be an acknowledgement of that. And beyond all that, this was probably on the website even before the law changed. I can't say that I can verify that 100%. But I think from the beginning, the Department of Labor has wanted, or the state generally has wanted, employers to provide the training in languages spoken by their employees. The bottom line here is that this red text, employers are strongly encouraged to provide a policy and training in the language spoken by the employee. I mean, the point of the training is to actually try to prevent sexual harassment, and it certainly doesn't do any good to have the training if the employees don't understand the training. But in a lot of situations, the law is referring to the employee's primary language, and that might be something different than English, ignoring the question of whether the person is reasonably fluent in English. So I think the concern is less if the employee is going to understand 100% of what is said because of their English fluency, despite the fact that their native and perhaps primary language could be Russian, for example. On the other hand, if you have a Spanish-speaking workforce or something like that where they really aren't particularly conversant in the English language, then you have a lot more motivation to make sure the training itself is provided in that language. But again, there is ultimately some gray area here as to whether you absolutely must provide the training itself in a language other than English in any situation. Now, what I'm going to do is jump off of this last comment where employers are strongly encouraged to provide policy and training in the language spoken by the employee to hit a couple more points and wrapping up. And what I want to do is, give a note of caution really to every employer in New York State at this point. And before I show you that, because again, the real point is to try to prevent harassment. The state is not going to like it if you don't complete your annual training requirement. That's clear. And if you do get a sexual harassment claim filed against you and you haven't completed your annual training, then that is going to be a big problem in that case. Otherwise, we don't know to what extent the state is really going to try to police the annual training requirement. I'm encouraging employers to not think of this as checking the box on doing something that the state requires, but to do something that might actually prevent sexual harassment. And while I would have said that this time last year, I have, renewed reason for emphasis given amendments to the human rights law that are taking effect soon. So among those amendments that the legislature passed in July and the governor has now signed off on are things that are going to make it a lot easier for employees to make successful workplace harassment claims under the human rights law. In some ways, these changes mirror what was already in the New York City human rights law. So if you have employees in New York City, you might already be subject to some of these lower standards. But now what I'm talking about here is going to be the case for all employers and all workers, including independent contractors and consultants, etc., throughout New York State. These amendments take effect October 11th, 2009, which, as I alluded to earlier, is, of course, 2 days after the first annual training deadline. The law will now be easier for employees to prove sexual harassment or any kind of harassment in the following ways. First, the long-standing severe or pervasive standard will no longer apply. Employees had to prove that the harassment was either severe or pervasive. Now they will just need to show that it subjected them to inferior terms, conditions, or privileges of employment because of their membership in one or more of the protected categories. So again, this is not limited to sexual harassment. It would apply for age-based or racial or national origin or any of the other dozen or so protected categories under the human rights law. The failure to have made an internal complaint is not, quote, determinative of a harassment case. So for a long time, there's been a defense available to employers to say that, look, we had a viable complaint procedure and the employee didn't take advantage of that, so they didn't give us an opportunity to prevent or resolve the harassment before they went and filed a claim with the EEOC or Division of Human Rights or in court. So under New York state law now, that will not be determinative. I think what the intent of the amendment is more or less to say that employees should not have to file an internal complaint before they can make a legal claim that they've been subjected to harassment. Question whether that will give more employees incentive not to make internal complaints. I think it's possible that that will be the case, which will make your job even tougher because the first time you find out about anything might be after the employee either leaves or otherwise has become disenchanted with the company to the extent that you're caught by surprise and can't do anything about it. The employee also need not demonstrate the existence of an individual to whom the employee's treatment must be compared. It's kind of the idea that employers would say, well, this person treats everybody that way, or the employee was treated this way, but there's nobody else who was treated any better. If, for example, that supervisor didn't have any other direct reports. Anyway, so that's another change, but you can see all of this goes in the direction of making it easier for an employee to make a successful harassment claim. The available defense to employers now is limited to showing that harassing conduct does not rise above the level of what a reasonable victim of discrimination with the same protected characteristic would consider petty slights or trivial inconveniences. So I think, putting this all together, what a reasonable victim of discrimination would consider only a petty slight or trivial inconvenience is bound to be a very low threshold. So I'll just kind of leave that slide with that. Move on to say that, and once those new lower thresholds are met, there are additional penalties that will be available. There will be punitive damages for the first time available to employees under the human rights law. This means not just the lost wages and some emotional distress damage, but an additional amount of money that a court, for example, or jury, for example, could award purely to deter employers from allowing or engaging in sexual harassment in the future. One key note here is there's no cap on how much those punitive damages can be, which is a big difference from Title VII, the federal law, which currently has allowed punitive damages, but with caps based on the employer's size and an upside for the largest employer's cap of $300,000. So there's no cap on punitive damages now under the human rights law, and they are available for the first time only for private employers. If you are a government agency or municipality or public school district, for example, in New York, you're not subject to punitive damages. There are now mandatory, or there will be in October, mandatory attorney's fees to prevailing plaintiffs. Previously, only in sexual harassment cases these were available, but it was discretionary, technically, to the court as to whether to award those fees. The defendants can, so the employers can potentially recover attorney's fees, but only if they can show that the case was frivolous, and with the particularly low standard for harassment now, it is going to be hard, I think, for any employer to demonstrate that the employee's claim of sexual harassment, for example, was frivolous. Now I just have a few final summary thoughts, and then I will take whatever questions you have. So I think there's no doubt that under these new standards, there will be more administrative claims and litigation over sexual harassment than there were before. There have already certainly been more in the last year than there were before that, not just due to any legal changes, but due to societal awareness and other factors that you're probably generally familiar with. It's also a reality that employers are likely to lose these cases more often and spend more, both in defending them or in the form of settlements, or if you do reach a jury verdict or other determination, say in the Division of Human Rights. So as a result, preventing harassment, including sexual harassment at work, is going to be now more critical than ever for employers. Unfortunately, there's still no magic solution. It's pretty much become a strict liability area. If it happens, then the company could be held legally responsible for it. Training at this point is probably the best and most cost-effective approach at trying to prevent sexual harassment and therefore the liability that could come along with it. I would suggest that you all plan to exceed the New York State training requirements. Meeting the bare minimum to check off the box is not likely to make a meaningful impact on the workforce in a way that is going to give you much comfort that you have done everything you could to prevent sexual harassment. And of course, don't ignore the other forms of harassment, because it is not just sexual harassment that the law applies to, although it is only sexual harassment that the state requires this annual training to be given based on. When I give this training, I certainly now focus on the sexual harassment when the goal is to make sure we satisfy the annual training requirement, but I also reference all of the other protected categories under New York law to make sure that people understand that pretty much everything we're talking about with respect to sexual harassment pertains to the other forms of harassment as well. Okay, so with that, I will take any questions you have. I'm going to make the slides available to you to download in just a moment. You will also get an email probably tomorrow that has a link to the slides. So if you don't want to download them right away, you will have access to it that way. That email will also serve as confirmation for those of you who might need evidence that you attended this training for some, licensing or accreditation program. I understand that. So again, go ahead and type in any questions. I'll give you a couple minutes to do so. Now you should be seeing the button to click to download the slides. Just remember when you're asking questions that there's no attorney-client privilege protecting the question and answer portion of this webinar that's open to people that both are or aren't my client. But if you have a question that needs that protection, or that you want to discuss more confidentially, you can contact me separately afterward to do that. So I don't see any questions yet. Oh wait, something just popped up. Oh, it's a good question about whether there's a separate training for supervisors and managers. Kind of interesting. So historically, my practice has been, I think, sort of what was considered the best practice was to train supervisors and managers together in most cases, but with a separate additional training session for supervisors. Or if that wasn't feasible, to train supervisors and non-supervisors separately, and the supervisor training would be more extensive than for the non-supervisors. Under the New York State requirements, you have to train everyone on issues specific to supervisory responsibility. So even the non-supervisors have to be told about the expectations and responsibilities, etc., of supervisors. So with that being the case, there's more logic behind just training everyone together, but some employers are still choosing to then have a separate session for supervisors to go into more detail for various reasons, either because you want to encourage more interaction and discussion with the supervisors over the topic, and you want freedom from having the people that report to them being involved in that discussion, or something like that, or other timing and logistical reasons. So, but there historically has been a lot of value in having the supervisors and non-supervisors together for at least the bulk of the training, so that they are all being told the message, and the non-supervisors see that this is all being told to the supervisors as well, and the expectations are being made clear to them. So like I said, that was a very good question. Are there any other questions? I will give another minute and see if anything's popping up. If you have a long question, just type in part of it or something so that I know that you're still trying to get a question in. So while I'm waiting to see if anyone else has any more questions, I want to thank all of you again for participating. Sorry for the brief hiccup in the middle where we lost sound, but I think I went back over everything that I had said. Again, make sure you get your training done before October 9th and consider the new requirements, especially giving out the policy and then the language issue to the extent that might apply to you. If you have any questions that I can help you with between now and October 9th, or after that, when you have to train again, remember things might change further. If they do, we will try to have more updates and potentially another webinar. But again, my bottom line message is to take this very seriously now that the state says you have to do it. put the time and effort into making sure you do it reasonably well so that you can actually achieve the most valuable end of hopefully preventing sexual harassment instead of just trying to be able to tell the state that you did what they told you to do. So I don't see any more questions. I will just end at this point, thanking you all and hoping that you have a nice day.